Well, joining us now for more on that is Jonathan Adler. He is a law professor at Case Western Reserve University and a constitutional attorney, speaking to us from Cleveland, Ohio. Jonathan, there's so much here, almost hard to begin. Now, but let's start with a very basic question many people are asking. As our reporter said, current Majority Leader Mitch McConnell may find it quite convenient to certainly hold off and let this proceeding happen only after Inauguration Day. And a lot of people are asking, can you hold an impeachment, a trial, an impeachment trial in the Senate after a president leaves office?
Well, the Constitution doesn't specifically say one way or the other, but there is precedent for holding what are referred to as late impeachments, impeachments where the trial and the decision about whether or not to disqualify someone from holding future office occurs after that person has left office. In one case, quite literally, the official who was being impeached tried to rush his resignation in to prevent impeachment at the last minute, and they went ahead and held the trial anyway. So in my view, looking at the historical practice, looking at the fact that one consequence of impeachment can be disqualification from holding future office, it makes sense that the Senate could still hold the trial after Donald Trump has left office, because one of the questions will be, should he be disqualified from holding future federal office again?
If we do see that happen, if the Senate does move ahead with that, does President Trump, or then will be Citizen Trump, have a legal redress to appeal to the courts? I would presume, I guess, to the Supreme Court in this case?
Not in the courts. The Supreme Court has been very clear historically that what constitutes a basis for impeachment, as well as what constitutes a fair process for purposes of impeachment, are solely decisions to be made by Congress. These are what we call non-justiciable political questions. And basically the idea is that because impeachment is also a mechanism that Congress may use against judges, it's not the place of the federal judiciary to tell Congress how to discipline judges. And so that would seem to apply here. Based on typical practice, however, if the Senate holds a trial, the president would have the right to be represented there, either seeking to address the body himself or to have attorneys make his case before the Senate. But it's a decision that the Senate would make. It's not a decision that courts would likely consider at any point.
Right. Now, I had Alan Dershowitz on my show just a few days ago, who said that you simply can't impeach a president on the basis of incitement as a high crime. He said basically the president is protected by freedom of speech. And if you say he's inciting, then you can impeach any president simply for making comments. So how do you respond to that?
Well, I think there's two important responses. One is it's long been understood that the phrase high crimes and misdemeanors does not refer to actual criminal offenses. Remember, the Constitution was adopted when there really was no federal criminal law yet. The idea of high crimes and misdemeanors are abuses of office. They are the violations of the oath that a government official takes when they assume their position. And so the abuse of their power is itself something that can be impeachable, whether or not it is legal. Particularly in terms of these sorts of comments here, it's important to note that historically, there have been impeachments based on comments made by officials that would otherwise be subject to First Amendment protection. There have been some of the earliest impeachments were about public statements that were seen to render them unfit for holding office that various government officials made. And so this would be in line with that. The real question is whether or not the sorts of comments he made, the context in which he made them, and the threat they may have posed to the peaceful transfer of power and the recognition of our democratic system are things that represent the sort of abuse of power for which someone could be impeached. So I think Professor Dershowitz is simply wrong here based on the historical understanding of what high crimes and misdemeanors are.
Briefly, Professor Adler, what kind of evidence do you expect the Democrats would present besides the obvious one of the speech that President Trump made that day in the Capitol?
Well, I mean, they're focusing on the speech he made. They're focusing on the false claims he made about what occurred in the election. You know, whatever election irregularities there were, they were not the sort that calls into question the result. There were not millions of votes that were fabricated or disregarded. There was not the sort of vote fraud or corruption of the system that could justify these sorts of claims. And so they're focusing on the combination of the false claims with the encouragement of people to take action and to prevent or discourage Congress from recognizing the vote totals. So that's what their focus is on in this particular ground for impeachment. Interestingly enough, they are not including things like the phone call to the Secretary of State of Georgia trying to encourage him to alter vote totals. A lot of scholars believe that that phone call itself could be an impeachable offense, and in fact, that the phone call, had it been done by a private citizen, might also be criminal. But that is not included in the articles of impeachment.
All right, Professor Jonathan Adler, thank you for joining us on the